The privilege against self-incrimination. We all know under the Fifth Amendment to the U.S. Constitution, we have this privilege against self-incrimination. So that is also one of the testimonial privileges. Meaning is that if someone if the prosecution wants someone to testify, and then if there is a possibility, if the person would testify, the person may incriminate himself, and then the person may invoke the privilege against self-incrimination, invoke this privilege against self-incrimination to decline to testify. It is important for us to know this privilege applies to the defendant and witnesses alike. In a criminal trial, it is not only the defendant may invoke this privilege, a witness may also invoke this privilege. But we need to understand what this privilege protects. This privilege against self-incrimination protects against criminal prosecution, meaning is only under the circumstances when it is possible, the person may be prosecuted for a crime, and then the person may invoke the privilege to decline to testify. This point is important because if there is no possibility of a prosecution, and then the privilege would not apply. Meaning is if there is no possibility of a prosecution, the party cannot invoke this privilege to decline to testify. We can look at these two examples. If the prosecution would say, I want you to testify, if there is a possibility of a prosecution, I can offer you this immunity from prosecution, meaning as you can testify if in your testimony you actually implicate yourself in a crime, but we would not prosecute you based on your testimony, meaning as the prosecution would offer this immunity from prosecution. So if the prosecution would offer this immunity, and then the party can no longer invoke this privilege to refuse to testify because there is no prospect of a prosecution anymore. Another example would be if the prosecution, if the protection against double jeopardy would bar for the prosecution, and then the party also cannot refuse to testify. We know in the Constitution we have this protection against double jeopardy, meaning is a person could only be prosecuted for the crime only once. The person cannot be prosecuted for the same crime over and over again. So suppose if this person has already gone through one trial, and then maybe the person is convicted, the person is sitting in jail, or maybe the person is acquitted, but after one prosecution, the person cannot be prosecuted again. If that is the case, if the prosecution would ask this person to come to court to testify about the same crime, maybe against a co-defendant, the person cannot invoke the privilege to decline to testify because the reason is because of this protection against the double jeopardy, the person cannot be prosecuted anymore. So whenever we have this situation, there is no possibility, there is no prospect of further prosecution. The person cannot invoke the privilege against self-incrimination to decline to testify. So that is an important point we need to understand. Another issue we need to understand is this. Both defendant and a witness may invoke the privilege, but there is a difference between how the defendant and a witness may invoke the privilege. First, let's look at the situation with regard to the defendant. For a defendant, the defendant may choose not to take the witness stand at all. The defendant may say, I do not want to take the witness stand because I don't want to testify. I will just remain silent throughout the trial. The defendant can do that. If the defendant chooses not to testify, and then he can do that, the prosecution cannot comment on the defendant's silence or the defendant's refusal to testify to the jury. Because if the defendant wants to do it, that is an exercise of his his right based on the protection against self-incrimination. Prosecution cannot comment on that. The defendant could also decide to take the witness stand, but refuse to answer any questions that may incriminate himself. The defendant could also do that. If the defendant would want to testify, and then the defendant could also take the witness stand. But when the prosecution is asking a question, and if the defendant believes to answer that question would incriminate himself, he can refuse to answer that question. He can say, I invoke the Fifth Amendment, I would decline to answer that question. So there are two ways the defendant may exercise this his right under the protection against self-incrimination. For a witness, the witness situation is different. A witness cannot refuse to take the witness stand. If a witness is called to testify, the witness has to take the witness stand. He cannot really say, I don't want to take the stand and then I'm not going to testify because I may incriminate myself. The witness cannot do that. He cannot refuse to take the stand. But once he's on the witness stand, if to answer any question, he believes he may incriminate himself, he can refuse to answer that question. So that is very important. For a witness, he has to take the stand, but he can refuse to answer any questions that may incriminate himself. So that is the difference between how this privilege against self-incrimination may be exercised by a defendant or by a witness. This point is very important for you to understand.